Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases and topics affecting New York City tenants. I am Michelle Itkowitz, and today we are answering the question, what happens to your apartment if New York City issues a vacate order with respect to your apartment? As always, first let's set the stage with some context. The New York City Housing Maintenance Code, Section 27-2139, allows New York City to vacate any building used as a dwelling, or they can vacate part of a building used as a dwelling, which constitutes a danger to the life, health, or safety of its occupants because of a structural or fire safety hazard, defects in the plumbing, sewage, drainage, or cleanliness, or any other violation of the Housing Maintenance Code or other applicable law. Now, when I say New York City can do this, I'm referring to two distinct agencies. The New York City Department of Housing Preservation and Development can issue a vacate order, HPD, or the New York City Department of Buildings, DOB, can issue a vacate order. Now, if either of these agencies later find that the conditions rendering the building or the part of the building that they vacated as unfit for human habitation, if they find those conditions have been corrected, they may revoke their own orders. So, first, we are going to look at what New York City and New York State offer as resources to answer this question. What happens if your apartment is the subject of a vacate order? Now, I'm going to warn you that the information online with these various agencies is not a lot, but I'm not here to find fault with the government or whoever else when there's not enough information out there for people. Rather, I see my job as to aggregate, organize, and present New York City with accurate and comprehensive information so you can make good decisions about your housing. We're going to start by looking at the HPD pamphlet. In the show notes, I'm linking you to a pamphlet on the HPD website entitled "Your Building Has a Vacate Order. What Happens Next?" Good place to start. So it tells us that the property owner must make all necessary repairs that led to the vacate order so residents are allowed back in the building. But it also warns that the owner may need to wait for insurance funding and be required to hire a licensed engineer or architect to file the necessary applications with the Department of Buildings, and that depending on the extent of the damage, this may be a lengthy process. And then the pamphlet seeks to answer the question, can I get updates on the work being done on the building, and how will I know when it's safe to return? And the pamphlet gives us this answer, that you can periodically check the Department of Buildings permit applications filed for your building online. And once you see that an owner has filed an application for DOB, you can sign up to receive automatic job status updates at a certain link. Again, the pamphlet's in the show notes and the link is in the pamphlet. And after the condition is corrected, this HPD pamphlet tells us that the owner must get the vacate order removed and that the owner has a responsibility to contact tenants when they receive a rescission of the vacate order from HPD. Okay, so now I want to stop with the HPD pamphlet for a second and just give some of my own commentary. Unfortunately, in my experience, this part sometimes does not happen. The landlord does not contact the tenants. Here's where we get into the central problem with this material. It would seem like it's in the landlord's self-interest to get your apartment fixed as soon as possible and get you back in as a paying tenant. But that's not always the case. Landlords sometimes have different agendas, sometimes not always legal agendas, which cause them to be happier that you are no longer there. and they may see your departure as an opportunity. Sometimes landlords are not so quick to be fixing things, and they're not so quick to be getting the vacate order rescinded, and they're not so quick to be telling you that they did. And that's where the central problem with this stuff comes up. And I intend to address that in a minute, but let's finish our study of the HPD pamphlet. The HPD pamphlet also suggests that another way to get updated about what's going on with your building after a vacate order is to register with HPD for emergency housing services, even if you do not need emergency housing services, because that office will try to contact you to advise when the vacate is being lifted. Again, some commentary by me. I'm not an expert in the shelter system, but I don't love this advice because I feel like if you have no intention of utilizing emergency housing services, why would you put yourself on a list for that? Even just the act of being on the list and being processed somehow seems like it's utilizing resources and taking away energy from people who actually really need the emergency housing services. And it also just seems like such a complicated way to find out that a vacate order is lifted. I think there are better ways. We're going to get to that in a minute. In fact, we're going to get to it right now because next we're going to look at what the DOB webpage has to say about vacate orders. It has a section on vacate orders. And the DOB tells us that another way to find out about the status of your apartment that's subject to a vacate order is to call the DOB Construction Enforcement Unit in the borough where the building is located. So that's probably a better way to go. But put a pin in that. We're going to come back to that on the tenant takeaway section. Next and finally, we're going to look at the DHCR information sheet on vacate orders. This is relevant for rent-stabilized tenants. So the DHCR is the New York State Division of Housing and Community Renewal. That's the state agency that has auspices over rent stabilization. So this advice is for rent-stabilized tenants. And there is a resource on the DHCR website called Tenants' Rights to Regain Occupancy After Fire Damage/Vacate Order. I will put a link in the show notes. Remember, this is only for rent-stabilized tenants, and this advises that the tenant should file an application for a rent reduction based upon decreased services in an individual apartment. There's a link to the form and the pamphlet. The pamphlet is in the show notes, or you could just Google it. This is an easy one to find. So then it goes on to tell us the DHCR will review your matter and then issue a written decision and order. And if they find out there is a vacate order and you can't get into your apartment, they will set your rent at $1 per month. And the $1 per month rent level will remain in effect until the owner files an application with DHCR and receives a DHCR order restoring the rent, which obviously can only be done after the vacate order is lifted. All right, so we have reviewed what HPD, DOB, and DHCR tell us about vacate orders. The problem is none of it answers the central question that most people have. Most people want to know what they do if the landlord is not moving ahead on the restoration process of the building and their apartment, or if the landlord is not moving quickly enough and the months are turning into years. And people also want to know if the landlord does engage in the restoration process, how does the tenant maintain their tie to the apartment so the landlord doesn't rent the newly fixed up apartment to someone else? There is a lot to say here. Let's get down to business. Now let's get into today's question. What happens to your apartment if New York City issues a vacate order regarding that apartment? Now first we're going to do a little law. And what you absolutely must know is that a vacate order is not an eviction or a termination of your tenancy rights. Let me say that again. A vacate order is not the same as an eviction, and a vacate order is not a termination of your tenancy rights. I'm getting that from an appellate division first department case from 1989 called Ident versus Vickers that tells us even though a premises has been evacuated pursuant to vacate orders which were issued to protect the public safety, that those vacate orders do not terminate tenancies. And that case is itself pulling from Court of Appeals case law. That's the highest court in New York. So the first thing I want you to know is that even if there's a vacate order, the apartment is still your apartment. However, there's another principle of law we need to put right next to that one. So there's a proposition that when a fire or other casualty damages a building to the extent that the owner has no real choice but to demolish it, then a prior tenancy in such a building ceases to exist. An easy way to think of it is if the building ceases to exist, the tenancy ceases to exist. So when there's a fire that reduces a building to an empty shell with no windows, collapsed floor joists, collapsed stairwells, no boiler, no electric, no piping, no other functioning systems, this effectuates a demolition of the building that operates to terminate the tenancies that had been there. We're going to get into it in a minute, but determining whether or not a building is effectively demolished is, as you would guess, a thing. But as we go forward now, for purposes of this episode, I'm assuming that your building and your apartment are still standing and it's not an empty shell. Then the question is, how do you get back into the apartment if that's your goal? And to answer that question, we're going to answer it in sections because, as with so much in New York City real estate, the answer depends on whether you're in a free market apartment, a rent stabilized apartment, or something else. Let's start with the free market apartments. For a free market apartment, we're going to look at your lease. That's the contract between the landlord and tenant, and it governs such situations. Now, I'm working with a standard form of apartment lease. Check your own lease. It may be different. But most leases have a section called fire or casualty. Fire or casualty, it will say on the heading. And the way such clauses typically work is this. If the apartment becomes unusable due to fire or other casualty, the lease gives both the landlord and the tenant the right for either to unilaterally cancel the lease. And in any event, the rent is reduced immediately based upon the portion of the apartment that's unusable. So if there's a vacate order and you can't use the apartment at all, your rent pursuant to your own lease would be reduced to zero. So then there's the option for the landlord to give the tenant a 30-day notice if the landlord is not restoring the apartment, but rather the landlord is tearing down the building or substantially rebuilding the building. As a practical matter, if you're a free market tenant, this is just for free market tenants, if the building is in really bad shape, the rebuild is not going to happen before the typical 1-year lease ends anyway. So really, you just want your security back and you want to go on with your life. The standard form of lease also contains a clause that says if the apartment is completely unusable and it's not made usable again within 30 days, the tenant can give the landlord a notice that also ends the lease and any obligations for you to pay rent, and you should get your security back. That's free market. But let's move on to rent stabilization because that's really where this has the biggest impact. What if you are a rent stabilized tenant and you have a rent that you can afford in a neighborhood that you like, that's close to your job, close to where you worship, close to your friends, close to your family? You considered this apartment your forever home, and now you have suddenly lost it. So let's start here. We're going to take the DHCR pamphlet advice and file an application for a rent reduction based upon decreased services, and your rent will be reduced to $1. As you just heard me say, your lease probably allows for your rent to be reduced to nothing anyway. But it's still good to file this, and we're going to, in the tenant takeaways, we're going to talk about why. So this puts your rent down to $1. And again, there might be an assumption that, well, my rent is $1. The landlord would like to have more rent, so the landlord's going to fix everything and get rid of the vacate order and invite me back in. But again, as the HPD pamphlet warned, even if the landlord is trying, between getting the insurance claim adjusted and hiring engineers and filing plans with DOB, it can take a while. So what can you do to make sure that the landlord is moving ahead as fast as possible and that the landlord is going to place you back in the apartment when the work is done? For that, you and or your fellow tenants may need to sue the landlord for an order directing the landlord to correct the conditions that led to the vacate order and effectuate the lifting of the vacate orders. These proceedings are brought pursuant to New York City Administrative Code 27-2115H, and they're commonly called HP proceedings. HP proceedings. And here are some things that you should know about HP proceedings in a vacate order situation. So first, these HP lawsuits can be brought by only one tenant, and you don't need a lawyer to do it. The court system is set up to work with tenants who are pro se, who have no lawyer. However, typically, most of the time we see these HP lawsuits in vacate order situations, it's often brought by legal aid, free legal services organizations that are excellent at what they do, and that legal aid is often engaged by a tenant association, a group of tenants. And we're going to talk about this again and the tenant takeaways in a minute, but I emphasize on this podcast a lot how important it is to have an active tenant association in your building and to be part of it. The point is, on the day that this terrible event happens, God forbid, it should never happen, but on the day the fire happens, that's the day you're going to wish there was a tenant association. So the day to become active in your tenant association or to create a tenant association is before you need one. Okay, so here's something else to know about an HP proceeding. And this is important. Neither the landlord's financial situation nor delays occasioned by the DOB permitting process, which we heard mentioned earlier in the HPD pamphlet, neither of those things excuse a landlord from their obligation to do the repairs. And this is where I feel like that HPD pamphlet misses the mark a little. It reminds us that the process can take a long time, and that is true, and it's good to warn you about that. But nevertheless, the statutes and the case law are clear that landlord's bad financial situation and the slowness of the construction approval process, those are not excuses not to get the work done. So I'm linking in the show notes to 2 New York City civil court cases from 2021 that lay this out nicely. One is by Judge Stoller, Reed versus 590 Maple Ventures, and one is by Judge Ibrahim, Sanjuro versus Milio. Slowness in getting DOB permits might be a defense against something like civil penalties, like landlord being fined, but it's not an excuse to not get the work done. So that's very important to keep that in mind, because you might call your landlord and they might say, oh, I'm sorry, I can't do anything. I don't have the money. Oh, I'm sorry, it takes so long to get the DOB process. But that's not an excuse to not do it. And by doing an HP proceeding and involving the court, now you have a judge who is moving this process along. We're going to talk about that again in the tenant takeaways. Now, another thing to look out for is if the landlord tries to say that the building is an empty shell. Remember, we talked about that earlier, using the empty shell defense and saying that the building essentially no longer exists, so your tenancy no longer exists. Now, if the landlord tries to assert this defense, the court might hold a hearing to determine whether or not that's true. Or in some cases, the court doesn't even need to hold a hearing. So I'm linking to another case in the show notes that's also very illustrative, and that's a 2020 case, another Judge Stoller decision, Vargas versus 112 Suffolk Street. Again, link in the show notes. And the judge puts it very nicely, and I'm paraphrasing a little. The judge says that the extent of repairs necessary has to be huge to outweigh the endurance of a rent-stabilized tenancy during a vacate order. The endurance of a rent-stabilized tenancy during a vacate order. In other words, it's very hard to destroy a rent-stabilized tenancy with a vacate order. And in this 112 Suffolk Street case, The walls, ceilings, and floors of the subject apartment needed to be fully replaced. The apartment really was gutted. But the building was still standing, and that the judge noted that. And the judge said, there are other apartments that aren't even subject to a vacate order. The building is there, the tenancy is there. So even if the whole apartment needs to be rebuilt, if the building is there, the tenancy is there. So at the end, if your HP proceeding is successful, the court will set a date by which the conditions must be fixed and the vacate order must be lifted. And if a landlord can't comply with that schedule, the landlord can go back to the judge and explain why it needs more time, and the judge might give them more time. But if the landlord misses deadlines set by the court without any good excuse, then the court has a couple of things it can resort to push the landlord along. One is that the landlord can be held in contempt pursuant to the judiciary law, and that's not good stuff. And or the judge can impose civil penalties, fines, monetary fines on the landlord pursuant to the administrative code. Okay, let's talk now about good cause eviction, our brand new good cause eviction regulatory scheme. Very new. We're all learning about it as it evolves. Episodes 25, 26, 27, and 29 covered various aspects of good cause eviction. Good cause eviction and a vacate order. This is what I can say at this point. Good cause eviction is another regulatory system that is tethering you to the apartment because it's requiring your lease to be renewed. So I would think the advice would be the same for a good cause tenant as it was for the rent stabilized tenant, to bring the HP proceeding to get the conditions removed and the vacate order lifted. Okay, so this has been a lot of stuff, and I'm going to pull it together for you in the tenant takeaways. First, let's get the housekeeping out of the way. This is not legal advice, and I am not your lawyer. But because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it is just terrible because I'm asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about. If you like our work, please give us those 5 stars and follow the show. It is time for the tenant takeaway. Tenant takeaway time. There are 2 dangers for a rent-stabilized tenant or a rent-controlled tenant or a good cause eviction tenant, anyone who wants to go back to their apartment when there is a vacate order. One is that the tenant might give up as the months and years go by, and the other is that the landlord might want the tenant to give up. So the real problem for most regulated tenants is that they move on with their lives and make other arrangements for housing as the months and years go by, and then if the landlord doesn't come looking for them or does come looking for them and can't find them, then the tenants never realize that they have the opportunity to go back into a newly refurbished rent-stabilized apartment or rent-regulated apartment. The bottom line is you need to stay on top of it. You need to stay engaged with the process if you want the apartment back. And by engaging, I mean the following things. Number 1, again, if there's a tenant association, be part of it. Don't wait for the stuff to hit the fan before forming or joining a tenant association. There's strength in numbers, and the flow of information is better, and the powers that be pay more attention to you. So you're going to hear me say it again, tenant association. Number 2, probably you're going to have to resort to the HP proceeding, seeking an order to correct and in order that the landlord effectuate the lifting of the vacate order. The landlord may be constrained by insurance and DOB issues, but the HP proceeding will get the landlord moving and will monitor the landlord's progress and will set deadlines that the landlord either has to live up to or have a good excuse not to be living up to. So there's a referee, there's somebody watching if you do the HP proceeding. And again, if you don't have a group of tenants and if you don't qualify for legal aid or if you can't afford a lawyer of your own, the court really is set up for you to be able to walk in there and file this thing on your own. Just bring your lease and the vacate order with you to the court and go from there. 3, If you're rent stabilized, do indeed file that application for a rent reduction based upon decreased services. Do this even if you're doing the HP proceeding. There's no reason you can't do both. Why? I like the DHCR thing because this creates an indelible record, a public record, that you are attached to the apartment. Whenever anyone on landlord's behalf does a due diligence on the building, like let's say the landlord is fatigued of the building and trying to sell it, and maybe somebody else, another group with more money, will come in and try to fix it, any potential buyer or bank, they will pull the DHCR records. If they're smart, they will. And they'll see this order reducing your rent, and then they will want to know where you are and what your status is. The point is, by filing the DHCR application for a rent reduction, you're sort of tethering yourself publicly to the apartment. And I think that is a level of protection that's not bad to have. Number 4, make sure that DHCR and the landlord and anyone else involved that you're dealing with, if you're dealing with a tenant association, if you're dealing with your city council member, make sure everybody has your current address, because remember, they can't be communicating with you at the apartment because you're not at the apartment. So if you're moving around, always make sure that they can find you, that they have your current email and your current mailing address. DHCR likes to mail things. They don't email things. So make sure that there's a mailing address that everybody has for you. Number 5, I like the DOB tip about if you really want to know the exact status of the vacate order and the landlord's attempts to lift it, you can call the DOB Construction Enforcement Unit. So maybe what you could do is you could give yourself a monthly calendar reminder on a certain day of the month, and every month just call up DOB and see what's going on with that vacate order. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.